Swayam Prabha. Digital India. Educated India.
Hello everyone, I am Professor Kavita Solanki at University School of Law and Legal Studies, Guru Gobind Singh, Indraprastha University, Delhi, Dwarka. This is lecture number 3, that is Employees Provident Fund and Miscellaneous Provisions Act 1952 of Labour and Industrial Law Part 2. This act is very important. Again, this is one of the social security legislations and it has been passed immediately after the independence. It has been realized like all the measures has to be developed and all the legislations has to be framed for the welfare of the workers. So in that way it is based upon the socialist principles. So when we talk about this act is that is the Employee State Insurance and the Miscellaneous Provisions Act 1952, into which how the contribution can be made from the salary of the employee and who would be entitled, who would be covered under this definition, where this act would be applicable, who would be coming under the definition of the employee, and who is the authority, how the administration can be made, what has been given under the Employee Provident Fund. We are having the other schemes as well for the protection of the workers, for the insurance we are having the scheme. So how the person can get the benefit, who is like so under this act all these schemes we are going to discuss. And when we talk about who is what is this organization, who would be maintaining all this thing which has been set up by the central government, and so how much the contribution can be made by the employer, by the employee for the benefit of the workers. So after the retirement they can get the benefit from this fund. So let's start into this direction. Employees Provident Fund and Miscellaneous Provisions Act 1952, it establishes a compulsory contributory provident fund, pension fund and the deposit linked insurance fund for the employees into the factory and the other establishment. It is very important that a minimum there has to be the 10 or more than 10 employees, those who want to get the benefit under this act. But sometime what happen, like if they are having this kind of the benefit would be given to those who are getting this minimum wages, they are getting the wages lesser than the 15,000 per month. So but if someone is getting the wages more than 15,000 and if with the consent of the employer and if the appropriate government they approves it, they can register under this scheme for this employee provident fund scheme. Here into this act we are having the 22 sections and the 4 schedules has been given, and this is basically it would be applicable where they are employing the 20 or more persons and they would be notified by the central government, and for this purpose the central board of the trustees has been set up, and we are having the Employees Provident Fund Association has been set up by the central government. The historical background, so it has been realized because after the independence it has been realized that we need some welfare legislations has to be set up for the improving the social conditions of our workers. That's why with this spirit this act has been passed. The applicability of this act is, it is applicable on the industries which has been specified into the schedule 1. The long list is given and it has been mentioned that long list has been given into the schedule 1. More than 100 industries are there, and if the central government feels so they can add more industries for the benefit of this scheme after giving the notification. So but minimum condition is like there should be the minimum 20 or more persons has to be there. Now sometime if someone wants to voluntarily register under this, they can go for that, but for this purpose the employer has to be agree and the government has to give the permission for this. And one more thing is, once they start with these kind of the social security legislation, sometime if they are having the lesser than this number, this threshold, once they start with the scheme, that would be applicable. In fact, if they have reduced a number, that once it will come into the force, it would be applicable irrespective of the threshold of the numbers. the employees covered under the scheme is a person who is employed for the wages in any kind of the work, manual or otherwise, or in connection with the work of the establishment, and who gets his wages directly or indirectly from the employer. It further includes if a person employed by or through a contractor in connection with the work of the establishment, the person would be entitled to get the benefit under this, or the person engaged in as an apprentice or trainee, it will not be included if that person has been included under the Apprenticeship Act 1961, or if the person already covered under the Standing Order Act, then in that case this person cannot take the benefit under this act. Exclusion is so certain establishments has been excluded where the government has notified that they won't be coming under, they are not going to include, they cannot give the coverage under this, but here the person, those who would be eligible, that person is generally, they are ceiling has been fixed, that is they are getting the 15,000 per month, the wages or salary, and it's mandatory for the employer, they must have to provide them the facility of the employee provident fund, because sometimes the new classes can be added if the central government feels so this act can be applicable or new class of the establishments, and so all these the payment can be made by the banks, and then for this notification can be that would be given by the government, but this act won't be applicable because it is not applicable to a cooperative society employing less than the 50 persons and working without the aid of the power. A newly set up establishment for an initial period of the 5 years will not be covered. Any central and the state government or the establishment having its own scheme. Sometimes what happen if they are running their better schemes, it is not necessary they would be giving the benefit, they would be enrolling all these employees under this scheme. So already if they are having the good schemes, it is not necessary they must have to enroll under the scheme. And so if someone has started the new industry, then in that case, because unnecessary the government, they want to burden the new industry, so this kind of the relaxation has been given it for the 5 years, so they can set up their business, and accordingly they employ, later on they can be included into any of the social security scheme. The objective of passing of this act is, it is because this financial security for the employees would be given to the employees on the retirement or resignation, or in case of the death, or because that's why it is the compulsory, this is the duty of the has been assigned it on the employer, because here into this scheme the employer would be making the contribution, and on the other hand from this contribution the other 2 schemes would be running from these contributions only, and on the other hand the employee would be making the contribution, and after the retirement or after the superannuation or in case of the death of the person, then this kind of the benefit can be given to the dependent or to the family members. So, and in case of the any kind of the disability has happened, then in that case these person, the family or the concerned one, they can get the avail this social security benefit under this act, and that's why this is a kind of the compulsory saving, and through this scheme they can promote the worker welfare, because otherwise when we talk about this kind of the schemes, it is not possible for the middle class employees, because due to the cost of living, it is not possible to save anything. That's why this is the kind of the compulsory obligation on the employer. They would be making the that's why they have to deduct the from this salary of the employees, and he would be making the contribution for this. So this is the kind of the compulsory deduction has been imposed. This scheme, basically there are the 3 schemes has been framed under this act and by the central government. So first scheme is, that is an employee provident fund scheme 1952, and the purpose for this scheme is they would be giving the benefit after the post retirement. And the other scheme is under this act is employee pension scheme 1995, and the purpose is after the superannuation, so pension can be given, to a retiring pension can be given, or permanent total disablement, so this kind of the benefit can be given. So these are the basically the insurance kind of the benefit would be this kind of the pension kind of the benefit can be given in case of after the superannuation, in case of the retirement, or in case of the total disablement. And third scheme is employee deposit linked insurance scheme. 1976. So under this scheme is benefit to the family in case of the death of the person while in service. Say for example, if the person was doing the work and he met with an accident, he died just because of any other occupation disease or relating into the course of employment and out of course of employment. For this, the benefit would be given to the family of the deceased under this scheme. These employees, those who are covered under this scheme is, when we see the eligibility criteria to join the Provident Fund is, this employee, general rule is an employee who's we can say that who is earning more than 15,000 per month is not eligible to join for the Provident Fund, because it would be, general rule is those who are getting the salary or the wages lesser than the 15,000 would be entitled. But this is the general rule. But sometime if the person is earning more than the 15,000, then in that case he can become the member of this Provident Fund, and with the permission of the Assistant Provident Fund Commissioner, and and with the permission of the employer. If the employer is agree, he has to take the prior permission of these two, that is the Assistant Provident Fund Commissioner and the employer. Then he can enroll into this scheme, because in such a case Provident Fund contribution will be as per 15,000 per month. So normally the wage limit has been fixed. Sometime if employee feels so he want to contribute more than this stipulated amount, then he won't be getting more benefit because the capping has been fixed. If the employee is wants to make the more contribution, then this is the choice of the person, but the employer would be giving the contribution which has been set into this act. And an employee after ceased to be the employee to be the member of the Provident Fund, because after attaining the age of 60 years, so he can avail the benefit at a particular age, that is a 60 years has been mentioned. He cannot continue with this scheme after the retirement and after attaining the age of 60 years. See, an important the definitions has been given under this. So I would be taking this definition once we'll explain the provisions. So second is Employee Provident Fund Scheme. Into this both the employer and the employee, so what they would be doing, they have to pay the contribution to this Provident Fund, and the employer has to deduct the contribution of the employee from the salary of the employee and pay the contribution to both the employers and the employees' contributions, and through a challan, and so they have to be approved by a bank, and the employees gets a lump sum amount including the self and the employer the contribution with the interest on the retirement. So this scheme is both the parties, employer and the employee, they would be making the contribution. So it has to be done in that way which has been prescribed under this act. So the schedule bank has been set up through which they would be, everything would be regulated, and so after the retirement, after post retirement, the person can get the benefit, and because he is entitled to get the interest of this lump sum amount, he can enjoy more benefit through this scheme. Sometime what happened, because if the government they want to add more employment, so central government they can consider and they can add more industries into the schedule 1, so the more coverage can be given under this act. So the administration of this act for the scheme under this act is we are having the central board has been created. So when we see the administration given under this act is done by the central board, it has been given in section 5A, and here the constitution has been given who would be the members. So central government would be making would be appointing the chairman and the other members under this board. When we see the for the administration is we are having the persons from the state government. So in section 5B we are having the state board can be created where the members has been notified by the government, and so regional committee can be set up by the government, the other members. So we are having, that is a chief executive committee can be appointed and constituted by the central government under section 5AA. And for this purpose, for the provident fund purpose, there is structure of the EPFO has been set up. So when we talk about this EPFO, that is an employee provident fund organization has been set up, and under this act all its schemes are administered by the tripartite board. And so into this, like when that is a central board of the trustees. So, and it has the representatives. See, tripartite board means the representation can be given by the government, state government and the state governments, employer side and the employee side. So they would be the members. So this board is chaired by the Ministry of the Labour and the Employment, Government of India, and Central Board of Trustees. This Central Board of the Trustees, they would be operating these schemes under this act. Okay, so when we talk about amount of contribution, which is very, very important under this act, is the contribution is 12% of the pay into 12% of the pay. It means we are saying that 12% of the contribution can be given by the employer, into which we are saying that is a basic pay plus GNS allowances plus retaining allowances. So that is 12% of these three, that would be given by the employer side. And so the contribution of both the sides, employer and the employee, is the same. That is a 12% from each side. And so if the employee, they want to voluntarily, they want to, sometimes they are interested, they want to ready for the more contribution about the statutory rate, they can, go for this. But there is an employee won't be, it is not the duty of the employer. They won't be contributing more than that. What is the statutory limit has been fixed. Voluntarily, the employee, they can give them more contribution. So the amount of contribution, so we are having the excluded employees, those who have been excluded from the employee provident fund, and employee who has withdrawn all the full amount. If someone has withdrawn all the full amount, then he will not be entitled. And an employee who exceeds the prescribed amount, say more than the 15,000, so he can be excluded unless until the person has taken the permission from the authority and the employer. And as we have discussed it earlier, the apprenticee or the trainee will not be covered under this if the person is getting the benefit under the Apprenticeship Act. So this was regarding amount of the contribution. After that, we are having the employee pension scheme. Here, this scheme is applicable to all the subscribers of the Employees Provident Fund. So basically, those who are the members and those who have subscribed Employee Provident Fund, they would be entitled automatically. They would be part of the employee pension scheme. So, and for this, this Employees Provident Fund can be diverted for this, because already they have taken 12% of it. So now from this fund, what they would be doing, Employees Provident Fund would be diverted for the employees' contribution of the 8.33% is diverted to the fund of the pension scheme, and the balance is 3.67% is credited to the employee's name into the Provident Fund account. So employees do not contribute. There won't be any kind of the contributions, because out of these 12%, only what they have done, they have divided the amount, that is like a Provident Fund amount. From this fund, they would be contributing for the Provident Pension Scheme as well as the Provident Deposit Linked Schemes, that is for the insurance. So they would be taking this amount from this 12%. So accordingly, and the member of this employee pension schemes will get a pension on the superannuation or the retirement from the service, or if anyone has become disabled during the service. So they would be getting the benefit, who would be getting the pension. So here we are having the system for the family pension, and family pension would be available to the widow or the widower for the life or until she or he marries. So because we are having the concept of the family pension can be given unless until the other spouse go for the marriage. So if they are not going for the marriage, they would be getting it. Once they are going for the remarriage, so this this scheme would be automatically ceased. So, and in addition, the children would be entitled to the pension up to the age of 25 years. And if a person is unmarried or is not having the family, then in that case, the pension can be given to the nominee for the specified period. They can give the benefit to the nominee, whom the person has appointed the nominee. This is employees deposit linked insurance scheme. Purpose of this scheme is to provide the life insurance benefits. So here the employees already, those who are covered under the employees provident fund scheme or employees pension fund schemes. So this, no need to enroll again under this scheme, because this is the third scheme is from, we would be taking this fund from the earlier that has been deposited by the employer. So for this purpose, the contribution would be given by the employer, and the employer has to pay contribution equal to 0.5% of the total wages of the employee. So whatever the wages of the employees, that is the person would be, this employer would be giving, that is 0.5% of the total wages of the employee under this scheme. That is a employee deposit linked insurance scheme. And this is duty of the employer is he has to bear the administrative charges, that is it is 0.1 of the total wages, or also has to be paid by the employer. And for under this scheme, the employee does not contribute any amount under this scheme. So this is the duty of the employer is he has to take care and he has to give for this scheme. There is no responsibility of the employee under this scheme. And amount of claim, how much the amount can be given for this purpose, like if any of the employees dies during the employment. So maximum assured benefit up to this 7 lakhs can be paid to the nominee or the legal heir of the EPF member. And if the death occurs while in service, so if the person was into the service, then in that case, so nominee would be entitled, or the legal heir can be entitled, and the benefit can be given for the 7 lakhs. But in case if the minimum assurance benefit can be given 2.5 lakhs in case of the deceased member was into the continuous employment for the 12 months prior to his or her death, because there is a less time the person was doing the work, only the last 12 months the person was doing the work, then in that case the minimum amount has to be given, that would be the 2.5 lakhs can be given it to the deceased members. So this scheme is, if someone is not making the compliance for this, then in that case the employer can be held liable under this act. So penalties has been fixed here in section 14. So, and the same roles has been given to the inspectors has been appointed, and they would be doing the similar kind of the functions. So section 14 is very, very important, because when we talk about the penalties, so here if the employer is avoiding any payment under this act, and whoever knowingly makes or cause to make, sometime he makes any false statement or make a false representation by the employer just to avoid payment, then in that case the imprisonment has been fixed, that is imprisonment less than 1 year or fine now of rupees 5,000, and sometimes the both can be given. And if the employer who contravenes or who makes default into the complying with the provisions of the inspection charges or the administrative charges, intentionally the person is making the contravention, default of the payment of the employee's contribution, there is the person can be punished for the 1 year imprisonment, and rupees 10,000 can be imposed as a fine. And in other cases 6 months imprisonment and fine can be imposed up to the 5,000 rupees. And the maximum imprisonment can be imposed here under this act is, that is 3 years. The important schedules has been given under this act is, and when we talk about, because already we are having the schedules are very, very important. So when we see that under this act we are having the 4 schedules is there. When we talk about these schedules, so into the first schedules, industry or the classes of the establishments has been mentioned where this act would be applicable. So here the general industries has been given, cement, cigarette, and the multiple industries. See, is a more than food and the processing industry, chemical and the oil industries, manufacturing industries, alcohol and the other special industries. So we are having the more than 100 industries. Schedule 2, so it talks about the matter for which the provision can be made into these schemes, because we are having the matters has been mentioned into these 3 schemes. So the matter has been given into this schedule 2. It can be incorporated under the schemes of the Provident Fund into this Provident Fund Act, and in other 2 schemes as well. Schedule 3, it talks about the matters for which the provision may be made into the pension scheme. So basically into the pension schemes, this kind of the matter can be mentioned into this pension scheme from this act. Schedule 4, it deals with the matter can be provided into the employees deposit linked insurance scheme. So we can say how the coverage can be given, fund management and nominations, record and the identification, insurance benefit, how the payment can be made, and the miscellaneous provisions, and the important cases has been mentioned. So when we talk about this social security legislation, so under the Pan India, it is applicable on all the establishments where the state central government has they are with the approval of the central government, so they can be applicable upon all these industrial establishments. And so this is a kind of the social security under this act. 3 schemes has been set up, so just to provide the more security to the workers, so they can contribute more for the economic growth of the country, and they can be relaxed. So there won't be any tension. They can think that they would be getting these kind of the benefits after the retirement, or in case of the any kind of the disablement or any kind of the problem if they are having. So this is a very good initiative has been taken up by the government. When we talk about Employee State Insurance Act, this is a social security legislation which has been, we are having the many social security legislation. When we talk about Employee Compensation Act, Employees State Insurance Act, when we talk about Employee Provident Fund, when we talk about Gratuity Act, we are having the multiple social security legislations. So here, when we talk about Employee State Insurance Act 1948, it would be applicable upon the employees, those who are doing the work into the government setup. So, and they are doing the work not into the seasonal establishments. So earlier, the employees, those who were getting the wages up to the 15,000, they were covered. But now this limit has been increased, and after making the amendment in 2016, so now those who are getting the 21,000, they would be entitled to cover under this act. So when we talk about this act is having 8 chapters. Employee State Insurance Act is having 8 chapters, and it contains 97 sections into these chapters. So when we see the object of passing of this act is, here it is an obligation of the employer to give the benefits to the employees and the members of their families. So in case of either it is a case of the sickness, or either we are talking about the maternity benefit, or like any kind of the employment injury has been, the insurance scheme has to be given it to this to employees. And for this purpose, an organization has been set up. Employee State Insurance Corporation has been set up under this act, and to supervise this scheme. So when we see the applicability of this act, it is applicable to the factories, including the government factories, and other than the seasonal factories where they are employing 10 or more persons, that this act would be applicable. and it can be extendable to the other establishments where the appropriate government, after making the consultation with the corporation or with the state government, with the central government, if they give the approval, then it can be extended to the other establishments. So they can include the industrial, commercial, agriculture or otherwise, and they would be mentioning into their official gazette. So after giving the notice, before including into their official gazette, so they can go for their extension. And when we see these kind of the schemes, they can be extended to the shops, hotels, restaurants, cinemas, including the theaters, roads, motor transports, undertakings, and newspaper establishments employing 10 or more persons, and also to the private medical and the educational institutions employing 10 or more persons, that is like into the states or either into the union territories. So they can be covered under this act, and so they can get the benefit. So when we see the persons covered, so this act covers any person who has been employed directly or through a contractor, so they would be covered under this, and they are drawing the wages up to the 21,000 per month, and it has been like after making the amendment in 2016. So earlier it was up to the 15,000 per month, or into the connection with the whole of the work of the factory or the establishment to which this act applies. So these person, they can be covered under this act. So we are having the important definitions under this act. Many definitions are the same which we have done it into the Employee Compensation Act 1923. So many definitions are same, like definition of the dependent is a very lengthy definition. So it's like a similar kind of the definition we are having, but the age limit has been increased here. Here the person would be entitled to get the benefit dependent. The person who is up to the age of 21 years, so the person would be getting the benefit. So other definitions say like the definition of family is very, very important. So family means spouse or the dependent minor legitimate or the adopted child, wholly dependent child, or the unmarried daughter till the age of 21 years. If the child is infirm, then in that case would be considered to dependent child or the dependent parent. So they would be coming under the definition of the family. So temporary disablement, we are taking the similar kind of the definitions which has been given there. So for this, just to get the benefit under this act, it is very, very important that in section 2A there should be the registration of the factories has to be there. So these factories or the establishments has to be registered, and for the application of this act, and within such a time and into the manner which has been specified into the regulation has been set up under this act. And after that, in chapter 2, so chapter 2 basically from section 3 to 23, it deals with the administration of the Employee State Insurance Act. So under this, the establishment of the Employee State Insurance Corporation. So this corporation has to be set up, because this corporation is, because we are having the basically for the administration, we are having the three things here. That is the Employee State Insurance Corporations, we are having the Standing Committee and the Medical Benefit Council. So and from section 3 to 23 basically deals with the composition of these members of this Employee State Insurance Corporation members. So their term, their functions, and the same is like Standing Committee members, composition, terms and the functions has been given, and the Medical Benefit Council's composition, terms and the functions has been discussed here. And when we talk about these three administrative bodies, so when we see that under this act is, it would be administered by the Employee State Insurance Corporation basically, and this is Employee State Insurance Corporation. Corporation is a body corporate, and it is having the perpetual succession, and they are having the common seal, they can be sued in its name. So basically chapter 2 deals with the administrative function, how the administration of the act can be done under this act. Chapter 3, it deals with the finance and audit. So into this chapter, basically here we are talking about how this fund is mainly derived from the contributions of the employees and the employees which are to be deposited into the fund, and the fund is administered by the Employee State Insurance Corporation. And so for this purpose, in order to ensure the workers against the sickness, disablement, and to provide the maternity benefit, funeral benefit, so who would be coming under the dependence benefit of the insured employees has been discussed under this. And this ESI Act provides basically for the creation of this Employee State Insurance Fund under Section 26, basically Employee State Insurance Fund. So here all the contributions and the money can be received under this fund, which has been paid into this Employee State Insurance Fund, and this fund is that would be administered by the corporation. So these corporations, they can accept grants, donations, and the gifts from the central and the state governments or the local bodies or the private bodies. And after that, this money would be, they can deposit into the RBI or the other approved or the scheduled bank, and this account would be operated by the these authorized officers. So basically into chapter 3, the finance and the audit part has been given. So how the fund can be collected, how they would be, this Employee State Insurance Corporation would be taking care of all these, administration can be maintained by this corporations. And after that, chapter 4. So chapter 4 is, it deals with the contributions. So basically into this chapter 4, here these employees, they would be insured. So all the employees, those who are doing the work into the factories or the establishments, they are covered under this act. And so if we are talking about the contributions, how the contributions can be made, so because under the ESI Act, it is contributory in nature. The definition of the contribution under this act is, it has been defined in section 2 clause 4, and it says that that is, contribution means to mean a sum of the money and has to be payable to the corporation by the principal employer in respect of the employee, and it includes any amount payable by or on behalf of the employee in accordance with the provision of this act. So how these contributions can be given, so employer would be making the contributions under this act. So this contribution is, we are saying that is what is the contribution period would be, so 1st April to 30th September and 1st October to 31st March, that is a contribution period is given. And sometime when we say that when this contribution becomes due, so the contribution payable in respect of each wage period shall ordinarily would be, they have to make it that is on the last day of the wage period. When an employee is employed, or that is sometime what happen, if the employee has been employed into the 2 establishments, then in that case the person is doing the work with the 2 employees, and so then in that case the contribution has to be, that would be due on such days that has been specified into the regulations. So here this is a duty of the employer, they would be making the contributions, and so these kind of the contributions has to be paid at such a rate that would be prescribed by the central government. So this amount of the contributions for the wage period would be the employer's contributions, when we say that that would be 4.75% of the wages payable to the employee, and on the other hand the employee's contribution, that would be 1.75% of the wages that would be payable to the employee. Newly amendment, and it has been with effect from 2016, the rate of the contribution has been, that is the 4%, 1% of being the employee's share and the 3% of the employer's share. First 24 months, this percent has been fixed. For this percent, 3% the employer's duty, and for the 1% it is the duty of the employees. And how they would be making the contribution is, because it is a mandate for both the parties employer and the employee, they would be making the contribution. So for this purpose, they would be making the contribution, they would be deposit this money either into the State Bank of India or any of the scheduled bank. So for this, the like through a challan or before the 21st of the month of the calendar month, the principal employer, and we are having the immediate employer as well, and where it was the duty of the immediate employer. So it is a duty of the immediate employer, they must have to give his due for the employee. Like this kind of the amount can be recovered from the immediate employer by the principal employer in that case. After that, the contributions part. Under this act, so many benefits has been given. So normally we have realized, if we see that normally we can see that like those employees who are registered under the Employee State Insurance Act 1948, for this purpose, when we see that or housing housekeeping staff or multiple, or we are having the good number of the employees. So when we see that, so for this purpose, hospitals has been set up. So in case of their sickness, in case of the disability, in case of the maternity benefit, in case of any kind of this kind of the benefit, so particularly the hospital has been set up where they would be getting the benefit under this. These hospitals, they are the part of the Employee State Insurance Act, so they can get the benefit through their hospitals. The benefit has been given under this act is, so when we see the benefit is, insured persons would be getting the benefit under this act, and their dependents, they would be entitled to take the benefit, and so they can take the benefit of the sickness benefit they can avail, maternity benefit can be given, or like disablement benefit can be given to these persons. It is related with the basically injury related disablement, and the dependent benefit has been given under this act. And when we talk about the medical benefit, the treatment and the attendance can be the treatment can be provided, sometimes the attendant can be given. And when we talk about the funeral expenses, so like the funeral expenses can be provided, and the funeral expenses can be given to the normally to the eldest member of the family, and for this amount has been increased now, so just to incurring these kind of the expenses, and so the limit has been fixed under this act. This kind of the benefit is so this kind of the benefit can be given to the either to the insured person or to the dependent and the family members of these persons. So sometime when sickness benefit, so for the sickness benefit, here the central government is authorized, they can lay down the like qualification of a person who can claim the sickness benefit, and it has been given in section 49 of this act is, so the person would be entitled to take this thing. So and for this purpose, here the liability of the owner or the occupier of the factory has been fixed for the excessive sickness benefit. So sometime what happened, if the corporation they consider that this incident of the sickness that has been excessive by the reason of that is a insanitary working conditions were there into the factory, so the benefit can be given. So the person is, if the occupier or the employer, they are not bothered about the maintaining the this kind of the hygienic condition in the factory, then in that case they would be accountable for taking care of these things. And if because they can go for the inquiry, and so after making the complaint, so here the government, they can go for the inquiry, they can assign a competent person for this, and if after making the inquiry, if it has been proved that excess incidence of the sickness is that has been caused of the insured persons due to the default or the neglect of the owner or the occupier of the factory, and then in that case the extra expenditure can be incurred on the sickness of this person. So that's why this kind of the duty has been imposed upon the this owner or the occupier of the factory in case of the excessive sickness. This is the duty of the employer is he cannot dismiss or punish any of the employee during the period of the sickness. So it is a duty of this employer is they can't dismiss if the person is sick during this period. They cannot dismiss or punish the employee. If we are talking about the dependent benefit is, so this benefit has been given to the dependent, like the insured persons, if the insured person dies, then in that case due to the employment injury, so then in that case the dependents, either it can be the if the person is no more, then in that case the dependents they can claim for the benefit if they are having these kind of the problems. So the central government would be taking care of all these things, and so this insured person, if it dies and without leaving behind any of the dependent, then in that case, so the dependent benefit shall be paid to the other dependent of the deceased at such a rate and for such a period that would be subject to the condition which has been prescribed by the central government. And when we talk about the definition of the dependent is, so the definition of the dependent has been given in section 6A, and this is the same definition which has been given under the Employee Compensation Act 1923, but only here is, that is point number 1, where we were talking about a widow would be entitled, a legitimate or the adopted son who has not attained the age of 25 years. Age was 18 years, but here we are saying the person would be entitled to get the benefit until he has attained the age of 25 years. The rest of the definition, the dependent is same which has been given in Employee Compensation Act. After that, when we talk about the maternity benefit, because this kind of the benefit has been given under this act is, so in section 50 it says that it provides the either someone who is an insured person and they are claiming the maternity benefit, so there is a it can be, benefit can be given at the rate and the period, so which has been prescribed by the central government. And now when we talk about the maternity benefit is, after making the amendment in 2017, so now under this thing, so here the amendment is into the Employee State Insurance Act 1948. It would be read with this Employee State Insurance Central. So here this thing has been incorporated under this act. So more benefit has been given. So here now 26 weeks of paid leave can be given for up to the children of 2, and 12 weeks can be provided if they are having the 2 children, or in case of the more than 2 children, then in that case 12 weeks can be given as a leave with the wages. This kind of the benefit can be given into the adopting and the commissioning mother. So now the more coverage has been given. 6 weeks of leave can be given with the wages for the miscarriage, and the additional month leave for the sickness arising out of the pregnancy can be given, and the medical bonus of rupees 5,000 can be given under this now after making the amendment under the maternity benefit. And as far as the funeral expenses are concerned, so under this act now, so this amount has been increased. So now the amount of 10,000 rupees would be payable to the dependent or the person who performs all these rites. And so those those who are that would be, this amount has been increased. So but sometime what happened, these kind of the benefits cannot be combined if any of the insured persons, if the person has received the other sick benefit and if something has happened, so this kind of the benefit, funeral expenses, cannot be clubbed with the other this thing. So they are the other benefits. For this purpose, we are having the medical benefit council has been set up. So they would be taking care of all these things. When we see that, so this is the duty has been assigned to this medical council. And after that, when we see that Medical Benefit Council in section 22, they are having the duty, so they can advise the corporation and the standing committee on the matters relating to the administration of the medical benefit, and so for this purpose they can grant the benefit, and for this power and the duties of the investigation has been given to the medical council. And if they receive any kind of the complaints against the medical practitioners in connection with the medical treatment and the attendances, so they can perform such a duties in connection with the medical treatment. So the power has been given to the medical council for this. They would be taking care of this part. After that, the last portion is, it talks about, that is chapter 6, adjudication of disputes and the claims. So when we talk about adjudication of disputes and the claims, for this purpose, the constitution of the Constitution of Employees Insurance Code has been set up. So here the state government can constitute the employee state insurance code for such a local area which has been specified into the notification. The composition of this employee state insurance code, so this code shall consist of such a number of the judges as the state government may think fit. So state government, they can appoint the same code for 2 or more local areas, or 2 or more codes can be set up for the same local areas. The qualification for this employee insurance code would be, any person who is or has been a judicial officer or a legal practitioner of 5 years standing shall be qualified to be the judge of the employees insurance code. The jurisdiction of the employee insurance code would be, it has been given in section 75, and it says that the matters can be decided by the employee state insurance code, and that is would be whether any person who is an employee within the meaning of this act, whether he is liable to pay the employee's contributions, the rate of the wages or the average daily wages of these employees for the purpose of this act, the rate of the contribution payable by the principal employer in respect of the employee, the person who is or who was the principal employer in respect of the employee, the right of any person to any benefit as the amount and the duration thereof. So these kind of the directions can be issued, and the claims can be decided. So here, because the claims can be decided by the employees insurance code, and relating to the claim for the recovery of the contribution from the principal employer, the claim by the principal employer to recover the contributions from the immediate employer. Sometimes the immediate employer, immediate employer, they refuse to pay to the principal employer. So that would be taken up by this employee state insurance code, and the claim against the principal employer, and the claim against the for the recovery of the value or the amount of the benefit which has been received by the person and who is not lawfully entitled thereto. Claim for the recovery of any kind of the benefit which is admissible under this act. And so sometime if they are having the determination of the special cases can be taken up. Say sometime the question comes for the disablement question arises and the medical board has to decide. So if there is any kind of the dispute relating to these kind of the special cases, then in that case they have to decide it. And if the person is not happy with the decision, then in that case they can go for the appeal, and that would be against the order of the employee state insurance code. So they can go for the appeal, and here we are having the system for the penalties and the damages has been given. So if someone is knowingly making or causing to be made by the false statement or make a false representation, then in that case the person can be liable and he can be punished with the imprisonment for a term which can extend to 6 months, or with a fine not exceeding to 2,000 rupees, or sometime with the both. And the penalty can be imposed if the person is fail to pay the contribution. So if the employer is making any kind of the failure on his part, then in that case he can be held liable, and so the person can be penalized, or if the person is doing such a kind of the act which is contravention of this and non-compliance of any requirement which has been mentioned, that he can be punishable. And under this power to recover the damages we are having, so under this, where an employer fails to pay the amount due in respect of any of the contribution or any other amount payable under this act, so the corporation may recover from the employer by way of the penalty such a damages, and not exceeding the amount of the areas which has been specified into the regulation. So they can, only within that, areas they can go for the damages. And sometimes the prosecutions can be made, and so no prosecution under this act can be instituted except or with the previous permission, sanction of the insurance commissioner and of such an officer of the corporation which has been authorized, and in this behalf by the Director General of the corporation. No court would be taking the matter, that is a metropolitan magistrate or the judicial magistrate of the first class, they can try up the matter, and no court will take the cognizance of any of the offence except on the complaint made in writing in respect thereof. So this kind of the we are having the system for the prosecutions can be made. This Employee Compensation Act 1948, this is a very good relief, and this is legislations. So under this schedule has been given, so total disablement, we are having this kind of the schedules has been cited here, and all the schedules are very, very important. So this act is very, very important when we talk about in terms of the social security benefit and the welfare of the employees. So this is from my side. Thank you so much.
Hi, my name is Gillette Sam, and I teach sociology at IIT Kanpur. One of the things you must have noticed if you read or if you talk to people around you is that they often refer to something called globalization, or they often say we live in a global world. What does this mean? Today I'll tell you about how to think about globalization or interpret the word global in a sociological manner. When sociologists refer to globalization, they refer to three things. The first is that that it involves transplanetary processes, which means that something is going on across multiple borders, right? The second is that it involves heightened liquidity and interconnected flows. Now, by liquidity, and this is a term that was coined by the sociologist Zygmunt Bauman, we refer to the increasing interconnectedness of things across the globe, but we also refer to increasing instability across the world, which means that potentially something that is occurring many kilometers away from you actually influences the place that you live in. So if there is a natural disaster happening in one part of the world, maybe that causes people to migrate from that area and they come and settle where you stay. So that is what we mean by liquidity. And of course, when we are talking about liquidity, we are talking about things that are really moving from one place to the other. Now, the third aspect, and this is something that you may not conventionally come across in the way people use globalization, is that of structures. So, let's take an example. Supposing I, as an Indian citizen, wish to visit a foreign country. Let's say I want to go to South Africa. Can I just pick up my bags and hop on the next plane and go to South Africa? any logical person is going to say, no, wait, you need to have documents such as your passport or visa. Now, this passport or this visa is a representation of the larger structure that governs how people move across borders. So, we have things like border control, national security agencies that consider what kind of people are going to move from one place to the other. Correct? So, when we think about globalization, an average person typically tends to think about things moving or people moving from place to place. As sociologists, we also consider that there are structures that facilitate or direct this movement across multiple borders.